Hello, everyone. This is group number 4, and our presentation today is on mistakes, fraud, and voluntary consent. My name is Matt Leahy.
I'm Thomas Metz.
I'm Andrew Galante.
And I'm Carly McAlevey.
The plan for our presentation today is to recap what we've learned in this week's chapter on mistakes, fraud, and voluntary consent, as well as go over our current event and how it relates to what we've learned this past week.
I'm going to talk about 2 factors and requirements for a contract. First being legality. Legality means the contract must be lawful purpose and not go against public policy. If any elements of legality, such as purpose, mutual agreement, and consideration are missing, then the contract would be void and unenforceable. In terms of our topic, mistakes, fraud, and voluntary consent, if a contract is to be a result of fraud, it may be voided by the party that was defrauded. They can typically refrain from damages for any losses that were suffered due to the fraudulent contract, but the contract will ultimately be voided. And for the next factor, which will be capacity. Capacity is the legal ability of parties involved to enter a contract. For a contract to be void, all parties must have the legal capacity to do so. So capacity involves age, mental capacity, and just free will and will. With age, most cases, parties must be at typically 18 years or older in many jurisdictions, and they have to have the legal capacity to enter into the contract. And in cases, sometimes minors can lack the capacity to form the binding agreements in the contracts. And for mental capacity, all parties must have the mental capacity to understand the nature and all of the consequences that come with the contract. And which is kind of self-explanatory, free will. The parties must be willingly to enter into the contract voluntarily without being subjected to being under the influence, coercion, or in our case, fraud. And if the party is forced into the contract through the fraudulent means, the contract may be considered voidable or unenforceable.
So the recap of 15.1 mistakes is a unilateral mistake is made by only one of the parties and does not give any relief to the misunderstood party. While on the other hand, a bilateral mistake is a mutual misunderstanding concerning a basic assumption on which the contract was being made and can be rescinded by either party in this situation. A word or term can also be rescinded if they are subject to more than one interpretation or meaning. The mistakes of value is when a mistake concerns the future market value or potential quality of an object in a contract. So for 15.2, fraudulent misrepresentation is when an innocent party is fraudulently induced to enter into a contract. This contract can usually be avoided because the party has not intentionally consented to its terms. But there are many specific ways that this can occur, including words or actions in person. Misrepresentations can occur in 3 different ways: in a statement of opinion, the misinterpretation of law, and in silence. Statement of opinion are not subject to claims of fraud, and misrepresentation of law also does not entitle a party to relief from a contract.
So leading more into 15.2, intent to deceive is basically the knowledge by the misrepresenting party that material facts have been falsely represented or omitted with an intent to deceive. So if we go into scienter exists if a party knows that a fact is not as stated, makes a statement that he or she believes is not true, makes a statement recklessly without regard to it, whether it is true or false. Basically, it implies that a statement is made on some basis, such as personal knowledge or personal investigation, when it is not. Negligent misrepresentation, innocent misrepresentation is a false statement or of fact or an act made in good faith that deserves any causes or injury to others. Negligent misrepresentation occurs when a statement is not true and is made without any reasonable belief in its truth. So if a fraud were to occur, then the deceived party must have justifiable reason for relaying on the misrepresentation. It also has to be an important factor and inquiry to the innocent party. In Chapter 15.3, undue influences. So it basically arises from relationships in which one party can greatly influence another party, overcoming that party's free will. So some examples of this: one party dominates the other party in court. So a child pressuring an elderly patient into transferring property, that's a big example. And then an attorney using their power to get money or free work from a client. Undue influence cases can be complex, and the legal standards and remedies may vary depending on jurisdiction. So the specific circumstances involved, in order to prove an undue influence case, you typically need to prove that said victim was subjugated to improper pressure. Then in Chapter 15.4, duress, the use of threats or pressure to force a party to enter into a contract. Examples of this is blackmail, extortion, which is seen in the real world. Rules to establish duress: the threatful act must be wrongful or illegal, and it also has to involve economic duress. So another real world example could be if you're being threatened with a gun, knife, or any deadly object to transfer money to another person. There are also 3 different types of duress, which is seen in law. This includes physical, economic, and psychological duress.
Okay, so now we will talk about the current event. In our current event, 3 military contractors were convicted on a court on account of defrauding the U.S., along with 2 counts of major fraud in March of 2023. Alan Carson, Valerie Hayes, owner and former vice president of Vastacom, we'll see why that's important later, and Philip Flores, each conspired to defraud the United States from September 2014 to November 2016. They prepared and procured sham quotes for government contracts worth $7.8 million. They also prepared independent government cost estimates and other procurement documents for the award of the contract. Along with making false statements, representations, and material omissions to federal contracting officials, they marked those estimates as legitimate and had the sham quotes become competitive. According to U.S. Attorney Ryan K. Buchanan, contractors are an integral part of our well-functioning government, and we expect them to be honest and forthright. With that, Carson, Haynes, and Flores were then each prosecuted and faced a max penalty of 5 years in prison and fines of $250,000 for conspiracy and a max of 10 years in prison with a fine of $1 million. Also, if the gross loss to the government or the gain that the defendants made or over $500,000, then it would be a $5 million fine. According to J.A. Johnson of LinkedIn, the typical private military contractors are to serve as armed guards and protect civilians, not fraud the government and make money for it. Now, how does this current event relate to course content? As mentioned earlier on 14.2c, the effect on illegality, the party at fault, which was Carson, Haynes, and Flores, used fraud to illegally create contracts that hurt the other party, which was the U.S. government. This was all an illegal bargain, and with the fines mentioned in the previous slide, based on how much that the gain the defendants made, will be what the U.S. government recovers as its value. There is also fraudulent misrepresentation, which was basically the preparing and procuring of the sham quotes, which were then used to defraud the United States government. There was also intent to deceive. This was when they decided to make false statements, representations, and material omissions to federal government contracting officials and marking those estimates as legitimate, with also the production of the sham quotes. There's also negligent misrepresentation. This was also when they prepared independent government cost estimates and other procurement documents for the award of the contract. And the last one was injury to the innocent party. The United States government was then defrauded and other contract officials were then affected.
And here are the audience questions. What are some examples of situations where fraud may occur during contract negotiations? Number 2, we have what are the potential consequences or penalties for individuals or entities for found guilty of fraudulent misrepresentation in government contracts? And after reading the current event, do you think there should be a specific measure or safeguards in place to prevent fraudulent activities, misrepresentation in the awarding of government contracts? And if so, explain. This is our works cited page. And thank you for listening to our presentation.